Welcome to Attorney-Client Privilege and Common Interest Scenarios, Walking the Waiver Tightrope. We are thrilled to have you join us today. My name is Courtney Patton, and I'm the co-chair of BHBA's Trust and Estate section. Before we begin, I'd like to take a moment to introduce Nancy Sanborn and Brian Joy of the Sanborn team. Nancy and Brian have been the official sponsor of this section since 2006. That's nearly 20 years. Nancy and Brian, please say hello.
Hi, everyone. Just a few moments. Everyone always kind of wants to know about the real estate market. So Brian and I thought we'd give you a tiny little update. Frankly, there has been a kind of a stall in the market since April. That seems to be the month that everything kind of took a little bit of a dive. So we're, we're finding now that when we try to price properties or help buyers look at properties, we have to be very careful on how we analyze what things are selling for.
Right. From the very beginning, if you price too high, the traffic drops, momentum fades, and the final price can slip. It's more important than ever to start at the right price and to get as many interested buyers as possible at the very beginning.
So it's not always the easiest conversation to have with people, but we're here to do it. So have a great meeting.
Enjoy.
Take care. Bye-bye.
Thanks, Nancy and Brian. In addition to the Sanborn team, the Trust and Estate section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Rosita Jacoby to provide this month's legal updates.
Thanks, Courtney. I will be presenting the case of the estate of Boyajian, case cited as G063155, 4th District, Division 3, filed on July 3rd, 2025. This case holds that the revocation of a will by cancellation must occur by physical alteration of the will, and a separate standalone document does not constitute a subsequent will unless it also transfers the property upon death. The decedent basically signed a 2-page holographic will in 2006 that bequeathed her entire estate to her daughter, Anush. In 2018, the decedent signed a second document prepared by her son, Robert, which purported to revoke all of the decedent's prior estate planning documents. After the decedent's death, Anush petitioned to revoke the 2006 will, which Robert contested. The trial court ruled in favor of Robert and held that the decedent died intestate. Anush appealed. The appellate court reversed and held that the cancellation of a will requires a physical alteration, and the subsequent will must be testamentary in nature and dispose of property upon death. The 2018 document did not meet the probate code's definition of an instrument because it did not reflect the decedent's testamentary intent, as it did not name a beneficiary and did not transfer or dispose of any property upon the decedent's death. Additionally, the document was notarized and not witnessed by 2 persons, which is required for wills, and such witness formalities are needed to turn a standalone revocation into a will. A more detailed summary of the case will be posted on the Beverly Hills Bar Association website. And now to Aubrey.
Thanks, Rosie. Now on to the program. Today's speakers are Michael Brophy and Garen Kirakosian. Michael Brophy is a partner in the Trust, Estate, and Inheritance Disputes team at Withers and is the regional divisional leader of their U.S. private client and tax team. He is also the office managing director of the Los Angeles office. Michael has extensive experience representing individuals, families, charities, corporate trustees, private professional fiduciaries, and creditors in litigation involving complex trusts and estates. Michael's diverse practice includes will and trust contests, accounting disputes, breach of duty actions, elder abuse, and conservatorship disputes, document interpretation matters, and other contested probate and fiduciary-related matters. Garen Kirakosian is a managing associate in Withers' private client and tax team. His practice focuses on litigating matters on behalf of individuals and families related to trusts, estates, and conservatorships, including trust and will contests, breach of fiduciary actions, accounting actions, and other related judicial proceedings and disputes. In addition to litigation, Garen advises fiduciaries and beneficiaries through the administration of trusts, probate, and conservatorships. He also advises clients on all aspects of estate planning, succession planning, charitable giving, and special needs trusts. Please welcome Michael Brophy and Garen Kirakosian.
Thank you, Aubrey. We are thrilled to be here today, and thank you all for attending. Today, Garen and I will be walking the waiver tightrope by looking at attorney-client privilege in common interest scenarios, specifically in the trust and estates world. Now, in our world of estate and business planning, confidentiality is vital. These are private family matters, and legal advisors are often given the most personal details about a family and its holdings. In litigation, such as will contests or contested trust administration, private conversations with one's attorneys are instrumental to creating legal strategy, addressing potential case strengths and weaknesses, and to address difficult questions. So with separately represented co-trustees, they may want the ability to collectively discuss beneficiary disputes or alleged breach of duty with their counsel present. And while the contours of the attorney-client privilege often differ by jurisdiction, the basic concept is pretty straightforward. Subject to some exceptions, a client has a privilege to refuse to disclose and to prevent others from disclosing a confidential communication between the client and the attorney. Typically, the communication must be related to the purpose for which the attorney was consulted or retained. But absent waiver by your client, the right is generally retained, and the right belongs to the client, not to the attorney. And a privilege may be waived if the holder of the privilege has voluntarily disclosed a significant part of that communication to a third party or consented to such disclosure. But in the world of representing beneficiaries and fiduciaries, some of these bright lines fray. For example, does your administration or litigation include a jurisdiction that follows the fiduciary exception to the attorney-client privilege, the so-called Riggs rule, where a beneficiary's right to information is often prioritized over the trustee's right to protect the attorney-client privilege? Does that jurisdiction impose duties on the attorney to disclose privileged information to the beneficiaries? Does it matter if the communications were made in a litigation context or a non-contentious administrative context? And while there are many topics of interest when thinking about the attorney-client privilege in the context of representing beneficiaries and fiduciaries, today's presentation focuses on the specific issue of purposeful, intentional disclosures of privileged communications and information to aligned third parties with common interests. Now, this doctrine is broadly called by many names. You hear the common interest privilege, the community of interest privilege, the joint defense privilege, the joint prosecution privilege. I've heard it called the pooled information privilege, lots of different names. Today, we're going to most commonly refer to it as the common interest doctrine. But with the many ways that the disclosure of privileged information under such an agreement can subsequently be deemed to be a waiver, it sometimes may feel like you're walking a tightrope no matter what you call it.
Before diving further into the common interest doctrine, let's briefly consider how waiver works when other parties are present or copied on what would otherwise be a privileged communication. When it comes to discussing strategy with clients, it's not unusual for them to want to involve other trusted friends, family, and advisors. But what happens when your client includes another party in privileged communications, like when you're co-defending a lawsuit or co-administering a trust? Or what if they just bring a friend to an estate planning meeting? Does this constitute a waiver? And if so, to what extent? There are lots of reasons why clients bring people with them to meetings, and it includes family dynamics, cultural norms, language barriers, and differing levels of sophistication. And knowing what relationships maintain the privilege or cause a waiver is an important consideration. And if you find yourself taking advantage of any of these agency type principles, like an authorized representative or a reasonably necessary person, how does that need to be formalized, if at all? And what risks need to be disclosed to the client before including those people on meetings and communications? There are many waiver possibilities in family situations, and lawyers are well served to discuss basic privilege concepts with the client at the start of every new engagement. I think one of the most important privilege concepts for a client to understand is waiver. Today's focus is on a doctrine that actually works to shield against waiver. We're focusing on people who are separately represented, but who want to collaborate on a legal strategy or defense. This is not a joint representation where an attorney is engaged by two or more parties. Joint representation generally eliminates the concern of privileged communications being waived by disclosure to a co-party. Our goal for today is to discuss common issues involved in the creation and scope of a common interest or joint defense relationship, which are instrumental in how a particular jurisdiction approaches claims of waiver. We'll also talk through how these issues are litigated, including the scope of a waiver, and focus on some special issues relating to privilege and aligned parties in the trust and estates context. There are certain unique issues that may arise regarding joint defense and waiver for parties like co-trustees, successor trustees, and in other cases where you have a change in allegiance. Finally, we'll conclude with looking at some best communication and privilege practices when addressing collaboration with aligned parties. Now, like the rocks in this photo, there's an art to balancing the benefits of sharing attorney information with the needs to maintain confidentiality. Careful control and instruction will allow you and your client to walk the tightrope of ensuring effective representation without compromising privilege.
And while precedent and laws governing common interest agreements vary somewhat from state to state and across federal circuits, we can start today's discussion by looking at a description of the doctrine in the third restatement of the law governing lawyers, section 76. It says, if two or more clients with a common interest in a litigation or non-litigated matter are represented by separate lawyers and they agree to exchange information concerning the matter, a communication of any such client that otherwise qualifies as privileged that relates to the matter is privileged as against third persons. Any such client may invoke the privilege unless it has been waived by the client who made the communication. Unless the clients have agreed otherwise, a communication described in subsection 1 is not privileged between the clients described in a subsequent adverse proceeding between them. So, as an introduction to today's topics, let's break this down further by focusing on the bolded phrases in the restatement. Two or more clients. You're going to need to be clear at the outset who is the client and who is each client's lawyers. Clarity on this issue will be key in establishing and enforcing your agreement and maintaining your ethical obligations. Indeed, common interests among multiple parties leads to confusion relating to client and counsel identity and can lead to inadvertent waiver. With families with many beneficiaries, for example, it is not unusual for some of the interested parties to attempt a free ride on the legal advice obtained by a family member rather than retain their own attorney. So it's going to be very important to understand who the clients are and who represents them. The next bolded phrase is with a common interest. In evaluating claims of waiver, whether the clients have a sufficient common interest, whatever that means, may be a keystone issue that may cause the entire waiver protection doctrine to fail. Is the communication sufficiently related to the common interest? What level of commonality? Identical? What about mixed business and legal discussions with counsel? The next phrase is in litigation or non-litigated matters. We'll talk about this more in a bit, but in some jurisdictions, like California, the common interest doctrine may apply to matters outside of the litigation context, which is one of the reasons why I prefer using the common interest doctrine verbiage instead of the joint defense agreement, which is more of a litigation context. But other jurisdictions, such as New York, on the other hand, require anticipated or actual litigation. If active or anticipated litigation is a necessary element in your jurisdiction, then the proximity of litigation will become the focus. Next highlighted is the phrase separate lawyers. That detail distinguishes a common interest scenario from a joint representation scenario. If one attorney is representing all of the parties on a side, then it's not a common interest arrangement. Those writing on the history of common interest doctrine in a lot of the cases have noted that early on in its development, counsel and courts often failed to make this distinction in certain filings and rulings, combining the concepts of joint representation with common interest. The next bolded phrase is agree to exchange. Agree. That means some sort of agreement is typically required. But what evidence of your agreement will be necessary is going to depend on jurisdiction. And if it's a formal written contract, will that contract itself be discoverable? That is often a debate in litigation. And it's not unusual for the parties to start operating under the common interest protection based on an oral understanding, later documented in a formal writing. Particularly if the discussion involves handling your aligned party's confidential information. There may be negotiations on how that will be handled during and after the litigation, and so that won't be addressed in the agreement until those terms are met, or and a meeting of the minds have been met. So this, of course, raises a lot of questions. When do courts recognize the existence of common interest agreements? How does one establish agreement? Can it happen on the telephone or Zoom? Or does it have to be writing an email? It could differ from jurisdiction to jurisdiction. But most courts, like those in California, require an express agreement, whether oral or in writing, to keep the common interest materials confidential. And what evidence does one use? That's another issue we'll talk about a little bit later, but can you establish a common interest agreement, an oral one, without revealing privileged communications? It can be a tough and thorny issue. And the final bolded clause is otherwise qualifies as privileged. Now, a common interest or joint defense agreement does not itself in California create a privileged situation. This is why I refer to it as a doctrine rather than a privilege. It's a non-waiver doctrine in California. Calling it a privilege can confuse some clients who think the existence of the agreement makes all communications with the aligned parties privileged. Instead, it provides a means to protect otherwise privileged communications from discovery. It's the public policy behind it is really for the purpose of further collaborating legal strategy and promoting efficiency. Now, some courts have, in fact, considered it an extension of the attorney-client privilege, but many others recognize it as an exception to the traditional waiver consequence of disclosure. Though today's presentation throughout, we'll expand on these issues.
Yeah, well, one of the challenges of the common interest doctrine is that it is recognized and applied differently across jurisdictions. Some states reference it in their evidence statutes, while California and some federal courts only recognize the doctrine in judicial opinions. The Supreme Court stated in its 1981 Upjohn decision that an uncertain privilege, or one which purports to be certain but results in widely varying applications by the courts, is little better than no privilege at all. And that makes sense, but that's exactly what we have is an inconsistent usage of the common interest doctrine across jurisdictions. However, despite that, patchwork of rules across jurisdictions, there are still some common elements we find regardless of the jurisdiction. First, you have that the information shared with the co-party would otherwise be protected from disclosure. Second, the participants in the exchange had a reasonable expectation that the information disclosed would remain confidential. And third, the disclosure was made to advance their shared interest in securing legal advice on a common matter. It's not too different than what Mike explained was set forth in the restatement. The purpose of the doctrine is twofold: to encourage the free flow of information and to enhance the quality of legal advice. Courts have reasoned that the doctrine's positive effect on the quality of legal advice benefits society by promoting justice and offers benefits to the interested parties and the system as a whole. The idea being that when counsel is more informed, they can provide better legal advice, and when counsel can cooperate, it is likely to save the court time. This, however, would be unlikely if the collaboration waived the attorney-client privilege. Now, let's pause for a quick second to acknowledge our favorite topic, ethical duties as lawyers. When considering the common interest doctrine, we must remember our ethical obligations as attorneys. Entering into a common interest agreement implicates the duty of confidentiality, the duty of competence and diligence, the duty of communication, and the expectation of zealous advocacy. I'll note that the ABA issued a formal opinion regarding the specific relationship between an attorney and allied parties in situations like common interest agreements, and stated that attorneys may owe the non-clients in the group certain fiduciary duties that are part of the agreement, but they do not become clients. For example, an attorney can be obligated to maintain confidences of the other parties, but this does not extend an ethical duty to the non-client members of the common interest agreement. And I think that distinction is important for, sometimes the inevitable when a problem occurs, because the harmed party will need to know what the rules, duties, and obligations are.
Great. And so a lot of states, when it comes to evidentiary issues, follow the Uniform Evidence Code. California does not. But because a lot of trust administrations touch on states that do have some version of the Uniform Evidence Code, we've included two examples of those types of statutes in the materials in the slide. And taking the South Dakota and Kentucky examples, looking at South Dakota, it says a client has a privilege to refuse to disclose and to prevent any other person from disclosing a confidential communication made for the purpose of facilitating the rendition of professional legal services to the client by the client or representative of the client, or the client's lawyer or representative of the lawyer, to a lawyer or representative of the lawyer representing another party in a pending action and concerning a matter of common interest therein. That's a mouthful, and it's similar to what we've been talking about, but I include these examples because what's interesting to note is that the Uniform Evidence Code and both of these examples focus on disclosure to counsel and not the aligned party. And what that means is a Uniform Evidence Code jurisdiction may not recognize a common interest protection to communications made from client to client if the attorneys weren't present. And so, again, thinking about how that impacts a multi-jurisdictional administration or a contentious case with a will contest in one state and a trust contest in another state can make these kinds of issues really glaring. But let's focus a little bit closer to home.
Yeah, so in California, the common interest privilege is not an independent privilege, as we discussed earlier. It's a non-waiver doctrine derived from Evidence Code sections 912 and 952. The common interest doctrine specifies circumstances under which disclosure to a third party would not be considered a waiver of the privilege. The attorney-client privilege is extended to parties who share communications with counsel where the parties hold a common legal interest.
So I'm a litigator, and clients usually do not come to me unless litigation is somewhere in the picture. And the most classic common interest scenario is the joint defense arrangement, where both parties are aligned in their efforts to defeat claims being made against them. These are often referred to as JDAs. But in these jurisdictions that require some proximity to litigation, even that line is fuzzy. And courts draw a number of lines, and walking these lines can become quite precarious. Some courts, example, may refuse to apply the doctrine unless there is some adequately anticipated litigation, either active litigation or adequately anticipated. In New York State, for example, there must be pending or reasonably anticipated litigation. And they had a pretty high profile opinion back in 2016 involving the countrywide Bank of America merger, where there were pre-merger discussions prior to the post-merger litigation, where the parties of the transactions were sharing confidential information. And in the discovery and the subsequent litigation, claimed that there was a common interest protection for the sharing of information between clients and separately represented clients prior to this litigation. And the New York court looked at the history of it and decided that, put simply, when businesses share a common interest in closing a complex transaction, their shared interest in the transaction's completion is already an adequate incentive for exchanging information necessary to achieve that end. Therefore, you do not need the common interest protection in order to encourage that kind of sharing. The court concluded that these policy reasons for keeping a litigation limitation on the common interest doctrine outweighed any purported justification for doing away with it. And so in that particular instance, discovery was permitted. And if you're interested in sort of diving into the scholarship of this, Judge Garcia in the AMBAC decision gives a pretty powerful dissent on why that shouldn't be the case and that the common interest doctrine should have protected that information. But even if actual or anticipated litigation is part of the required analysis, we see courts in various jurisdictions using a number of approaches. We've seen the the joint litigant scenario. That's the most easiest one. That's the JDA. That's pretty. That's when the litigation is actually pending. So that's a pretty easy one to apply. But what about the jurisdictions like the Fourth Circuit federal courts that look for contemplating litigation? Well, what does that mean? And so if you don't have a very clear idea of what contemplating means, you may have a line drawn on what is protected by the common interest doctrine and what is not. That won't really be known until it's litigated. In a federal court in Colorado, another test was a strong possibility of litigation. All right, so it's not just contemplating litigation. Now the scale's tipping towards litigation. Strong possibility. Again, seems like a pretty problematic standard when you're trying to decide where the line is. And this deciding where the line is usually comes up in discovery when they're trying to seek the information that the members of the common interest agreement are trying to protect. We saw in the Fifth Circuit a palpable threat of litigation. Not sure how palpable threat is different than contemplating or strong possibility, but it sounds just as problematic in its application. Now, Garen outlined how in California, the common interest privilege is a non-waiver doctrine, and it's derived from Evidence Code sections 912 and 952. Like California, some states and federal courts also recognize a broad common interest approach, recognizing the doctrine in non-litigation contexts where legal interests are aligned. We've even in certain federal courts in states that don't recognize pre-litigation common interests have found it in certain transactional settings, taxpayer settings, patent settings. But in California, you're going to see the focus is going to be on whether the communications related to the legal advice for which the communications were intended. That's sort of analysis. So it doesn't become really about the proximity to litigation, but whether the common interests are focused on shared legal interests relating to the purposes of the advice. And so even in that kind of broad application, there's a broad variation of what might constitute the proper circumstances to merit a common interest agreement. And you see this pop up a lot in disputes where parties on opposite sides of a lawsuit are aligned against a cross complaint. Courts that have various rules regarding pre-litigation, post-litigation, if these folks were talking with one another before the cross complaint was filed or trying to prevent the cross complaint from being filed. Is this a situation where it's sufficiently close to litigation? You can have a very complex analysis when you have cross complaints and various allegiances. And so, looking at our common scenarios, what would happen if you had a trust governed by California law with one beneficiary in Illinois, one beneficiary in Texas, one beneficiary in Pennsylvania, all aligned in litigation, all separately represented against, let's say, a corporate trustee in Florida. And there's a Florida trust action and a lawsuit against the trustee in the federal courts in Texas, as well as an estate matter in California. Well, to feel comfortable proceeding with a common interest agreement under those circumstances, in order to collaborate and not waive privilege, we would need to make sure that we considered choice of law and how each potential jurisdiction might consider the waiver doctrine. And have we sufficiently warned our client before engaging in this common interest discussion that the answer may not be 100% clear?
Yeah, and in a lot of these cases across jurisdictions, the issue of the commonality of interest becomes the focus of the court's analysis. Therefore, I think it's always important to be mindful of what jurisdiction or jurisdictions you're potentially operating in, and be mindful of the rules and precedent, ensuring there is a commonality of interest under their doctrine or privilege or whatever it is that you're operating under. For example, some courts require that the legal interest be identical rather than merely similar or overlapping or aligned. In California, in order for it to apply, the parties don't need to have an identical interest for the doctrine to apply, but it must be a legal interest. For example, in the Raytheon case, the defendants were being sued for toxic contamination, but were found to still have a common legal interest necessary, even though the liability shifting could have changed the outcome for each party. So even though the defendants, basically could have shifted the burden from one to the other depending on how it came out, they were still found to have a common legal interest. And having a legal interest it needs to be distinguished from having just simply a commercial or business interest. California courts have rejected applying the common interest doctrine where disclosure was made to a third party that has simply a commercial benefit in the outcome of a case, but isn't litigating the same or similar legal rights and claims. Other courts may also draw a line between legal interests and things like financial, business, or personal interests. And some jurisdictions permit parties on opposite sides to share common interests against a third party. I think Mike covered that a little bit when you've got cross-complaint issues, but some others will not allow that. Being aware of what the governing jurisdiction says on these types of matters is critical in determining if there is sufficient commonality of interest to prevent the waiver. This could potentially create an issue, communications regarding trust or estate challenge, and what communications regarding whether you have litigation or administration communications, that it blurs the lines. So it's important to be mindful of what counts as a common interest.
And just as you're looking at the commonality of interests, you need to consider the role counsel's participation plays into the analysis. As mentioned earlier, a uniform evidence code jurisdiction may require counsel to be involved. In those jurisdictions that don't have that requirement, what level of connection to the legal advice is necessary for it to be covered by the common interest protection against waiver? So if you have a client-to-client discussion talking specifically about the legal advice from a prior communication, you may have a fight over whether or not that is sufficiently within the common interest protection because the attorneys themselves were not there. It's also important to ensure that your clients and the other parties are aware of exactly what information is protected by the common interest agreements, so they do not accidentally communicate what they believe to be privileged information in a non-protected way. And so you may think it's completely fine sending all of the privileged information to your children, but the children aren't part of the common interest agreement. Their interests aren't entirely aligned. You may have completely blown the non-waiver protection by a disclosure to a third party who doesn't fit under the protection umbrella. I will note that in the Second Circuit, where counsel needs to be present, there is a case that came out in 2017 about two joint defense litigants who were in the hallway of the court discussing the advice and the strategy of the case, very clearly discussing things that would have been privileged if the attorney was standing next to them and giving them advice on it. But because they were talking outside the presence of counsel, and we're not seeking legal advice, the communications were not for the purpose of obtaining legal advice. In the United States versus Krug case, discovery into testimony regarding those discussions was permitted. And so even when attorneys are involved in the relevant communications, the substance of the communications at issue also matter. You heard earlier Garen talk about the mix of business and legal issues happens frequently in trust administration issues and in trust litigation. Talking about business issues relating to the administration of the trust often happen in the same communications where you're talking about joint legal strategy in a common interest call. And so it's not nearly sufficient for counsel to be on the email for the information on that email to be protected under this agreement. The substance of the email itself must be analyzed to see if it furthers the common interest. Some guidelines I like to keep in mind is, ensuring a connection to the purpose of the agreement, being mindful of not straying away from legal topics, making sure you've educated your clients on what that means, and ensuring that the conversation does not stray into topics where interests may directly diverge. So you may have a situation where, it is absolutely related to the legal issues, but you've spread your scope into areas where the aligned parties on issue A are adverse to one another on issue B. And so you may end up waiving the privilege on discussions relating to that where they don't have a common interest under the relevant law. It's also important to keep in mind that the substance requirements for what is protected by the attorney-client privilege in the first instance. There are lots of presentations on, what is necessary in order to have the attorney-client privilege protection. But a lot of them talk about sort of like the California Evidence Code 952, that it includes a legal opinion formed and the advice given by the lawyer in the course of that relationship. And so you have a two-step analysis often in these common interest scenarios. First, is the initial communication actually protected by the attorney-client privilege? And then is it waived by sharing it with another party who's separately represented and their counsel? So you have that two-step analysis. And you can see where the problems will pop up all the time, like in a co-trustee situation. They are separately represented, but want to discuss with counsel the potential litigation raised by a beneficiary. But in the context of that first discussion, you say, yes, we're going to have a common interest. But then you start talking about their own beneficial interests, which may be adverse to one another. They start talking about trust opportunities, business opportunities. So suddenly now we're into administrative discussions. And what if in the context of the discussion, in the beginning, you were aligned, but halfway through, your interests or thoughts on how to mitigate certain damages diverge? At what point does the discussions done with one another lose the attorney-client privilege and lose the non-waiver protection of the common interest doctrine? The substance matters, and you want to stay on the correct side of the line to rely upon the common interest doctrine to avoid that waiver.
So now that we've gone over the background and the rules, let's kind of do a real world application. You find yourself, you've shared privileged information with an aligned party under a common interest understanding. When does the trouble begin? Typically in the discovery process or in response to a subpoena. Going back to our presentation analogy, someone begins shaking your tightrope. Usually starts with discovery requests or subpoenas that seek privileged communications protected by the common interest doctrine. The party opposing disclosure will serve objections, preserving the privilege, and should provide a privilege log. The log should identify sufficient information to establish the privilege and that it falls within the common interest doctrine. If that's not sufficient, the propounding party will file a motion to compel. Then the court will analyze if the withholding party has made a prima facie case that the matter is privileged. Generally speaking, the burden of establishing the common interest doctrine falls on the party who asserts that a certain disclosure is not a waiver under the doctrine. Assuming the privilege log is adequate, the court may be able to rule on the objection just based on the contents of the log. Another thing you can do, a party can also request an in-camera review to avoid any further disclosure until the court rules on the objections. But I think it's important to note that an in-camera inspection is likely unnecessary where the party claiming the privilege has failed to make a prima facie case that the documents in question are privileged. More often than not, waiver issues occur due to some of the following issues, lack of clarity of what is necessary to create a common interest agreement, questions regarding the commonality of the parties' interests, a lack of understanding regarding the scope and protection of the agreement and what role lawyers play in the agreement and preserving the privilege. And oftentimes there's a failure to provide sufficient evidence to meet the level of proof to show that it was information exchanged under a common interest agreement. This can happen on a number of fronts. Failure to establish the privileged status of the communication, failure to meet the proximity to litigation requirement, the nature of the shared information between the parties. If it's not related to the litigation, is it going to be free from disclosure, or the generally the substance of the communication. Is it related to legal issues, and is it related to legal issues that are relevant to the common interest agreement? I mean, just because it's a legal issue doesn't necessarily mean that it would be free from disclosure under the common interest doctrine. Another thing to consider is the inclusion of outside professionals like an accountant who is assisting in providing legal advice. When deciding if the common interest doctrine applies, the court will scrutinize the inclusion of an outside professional and whether proper measures were taken under Cobell principles to shield disclosure.
And on the issue of disclosure, it's worth touching on a few other related concepts. First, the consideration of the timing of the disclosure. If your client is considering a common interest agreement in the future, disclosures of privileged material they make prior to the determination of that common interest may be deemed a waiver of the privilege. If you disclose information after the interests diverge, it can also be a waiver. Timing matters. Secondly, there is a consideration of who the disclosure is made to. Was it made to the client alone or the client and the attorney? As we talked about under a model evidence code jurisdiction, that could be material. But even if the inclusion of counsel isn't necessary in your jurisdiction, have you considered the third parties and their relationship to the engagement? And have you have a solid footing that the third party's presence is necessary to the representation and does not constitute a waiver? Third is the question of who holds the privilege and has the power to control disclosure, including waiver. And as mentioned at the beginning of this presentation, privilege belongs to a client, not to an attorney. And it is not uncommon for disputes to arise between and amongst participants to a common interest agreement later on their relationship. Therefore, it is important to understand as a general rule how these communications function and where the privilege may be asserted and waived. Now, participants generally may not assert privilege over communications previously shared with now adversaries while operating under a common interest agreement, but you may still have the ability to protect those disclosures from third parties. But they may also assert privilege over information they did not previously share under the common interest. So the privileged communications that occurred but weren't shared do not need the common interest doctrine protection because they weren't disclosed. You know, I think this leads into the fourth point, and that is the recipient's conduct matters. Is a participant in a common interest arrangement acting inconsistently with the confidentiality requirements? You know, for an example, that the other party that's aligned with your client is a blabbermouth. And you hear rumors that he's talking about common interest things all the time, and you don't do anything about it. You could be in a situation where knowledge of this person's lack of maintaining the confidentiality is going to eviscerate the protection that this agreement might provide. The conduct of the participants must be consistent with the desire to maintain the confidentiality of the privileged materials. So, for example, starting a communication in a common interest scenario that says, please share this with the court, well, that might be an indication that you did not intend the communication that followed to remain confidential. It's something that would have to be analyzed. A fifth point would be this concept of implied waiver. So this happens all the time where a party claiming privilege has placed the privileged communication directly at issue in the matter, haven't disclosed it, but made it an issue in the matter. And the disclosure of that matter is essential for a fair adjudication of the action. And under those circumstances, waiver may be found. We could do an entire hour on implied waiver, so we won't spend a lot of time there, but you can see how that would apply in situations where there's an advice of counsel defense, good faith defense, the use of exculpatory clauses that allow you to rely upon advice of counsel. And so when you have the situation where there's an implied waiver and you have already taken confidential information from a co-party, how does your agreement with that co-party impact your ability to even make the defense? Because you can't waive their privileged rights under the agreement. So you'll have a contractual obligation that may interfere with your ability to raise these defenses because of the implied waiver. It's definitely an issue to consider on how you can raise the necessary defenses and anticipate how the court's going to handle the waiver issue, particularly when there's an aligned party who's not raising that defense. Finally, just a word on inadvertent disclosure. It isn't true under most states' laws that if you reveal a privileged piece of information accidentally, that it's automatically a waiver. In most instances, it is not, as long as steps were taken to immediately alert the recipient of the error and the request for its return. And so it really comes down to what is the evidence of a party's intent to waive. And so if it was clearly done in an accidental form, then you may be able to establish that you did not intend to waive and that the disclosure was inadvertent. That can be a battle when it is clear that someone meant to disclose a bunch of information. They just accidentally included something they didn't. How do you show that you didn't mean to include that one thing? That could be a very difficult thing to establish. And once the disclosure's out there, you're going to have to show that the waiver is not such that it should be disclosed or used at trial. And so, I think one of the reasons why we're all here today is to think about how common interest agreements impact the trust and estates world, and that sort of leads us to discuss some sort of potential special issues in this field.
Yeah, and some of the issues with common interest agreements, or rather relying on common interest agreements, is the choice of law is always a problem. It's always something that needs to be considered because it could impact the effectiveness of your common interest agreement, and what is disclosed under the common interest agreement can remain confidential. We were recently involved in a matter with an institutional trustee who was in litigation with beneficiaries, and the matter was initially in state court. It was settled, and then the settlement fell apart. A new lawsuit was filed, and then that lawsuit was removed to federal court. Each of those steps, the first jurisdiction, the settlement, the breakdown of the settlement, and then the removal to federal court, potentially impacts the common interest agreement and what elements need to be met in order to preserve the waiver.
Another hot topic is litigation funding, the use of outside funds to help pay for litigation costs in exchange for some interest in the outcome. You see this more and more in the trust and estates world. And while there's a lot been written on sort of the ethical duties to prevent outside funders from directing the engagement, we're seeing a divergent of thinking on whether the common interest doctrine would protect the disclosure of privileged information to these funders, because they often want to know what your claims are going to be and your basis for your claims, and that frequently can involve things that involve the attorney-client privilege. And so if you're in a state like Delaware or Illinois, courts there have found that voluntarily sharing privileged information with a non-party funder is a waiver. But if you're in states like Pennsylvania and Florida, there are cases that say, no, this information, when disclosed to a funder, maintains the confident in a confidential manner, maintains the privilege. And in one state, Nebraska, actually codified that the confidentiality of attorney communication shared with litigation funders is protected under their statute. And while the litigation funder question is still in flux in California, there was a state bar opinion in 2020, it's 2020-204, that discusses the issues of litigation funders. And that opinion stated that the lawyer should take appropriate steps to limit the risks to the client, that the disclosure of privileged information to a litigation funder will affect a waiver of the attorney-client privilege or work product protection. This may include having the funder sign a non-disclosure agreement, appropriately labeling shared materials as confidential, and taking other steps to maintain the confidentiality of the shared materials. And while this state bar opinion wasn't on the issue of whether the common interest privilege applies, that language certainly suggests that protection could be appropriate if the materials were handled in a confidential manner.
The role of a fiduciary also has its own issues with respect to the attorney-client privilege, and the knock onto that is the common interest doctrine. For example, you may have a mix of either communications or calls and meetings that are administrative. Some are related to the administration of a trust, some are related to the litigation. When you have an overlap of that, it creates for potential problems in figuring out what is subject to the waiver and what is not. Sometimes you also have different people assuming, different but related roles, one as a trustee and a different person as an administrator. And, how does that impact the other party's potential access to privileged communications related to the trust? You could also have a situation where you have a beneficiary serving as fiduciary, and the dual role further complicates the analysis regarding, what the commonality of interests are and who they have those common interests with. There's also the situation, Mike touched on it earlier, the fiduciary exception jurisdictions, where, you know, a party to a common interest agreement will need to be concerned that an aligned trustee will be forced to share information with beneficiaries. You know, situations like this just heighten the tension between the duty to inform beneficiaries and the obligation to maintain the confidences with the other people in the common interest agreement. We also have potential issues with agents and employees. I know fiduciaries often use agents and employees um, through the administration of a trust and often through litigation as well. And, you know, while basic privilege rules often protect these communications, it's important to be mindful of the rules and those different roles and how they can create issues under the common interest doctrine. You know, for example, you know, there are circumstances, there are questions as to whether the communication of information would be waived or not if you have agents who are performing non-legal services, or if the agents and employees are not, you know, properly educated on the terms and the scope of the common interest agreement. You know, what do they need to do to comply and maintain the protection of the different communications? Then you also have the issue of the agents that may be, you know, continuing to be involved past the term of their agency, and how does that, you know, open up those communications to waiver after the fact.
And while the large focus of the common interest doctrine is what happens during discovery in active litigation, you need to give some consideration at the outset to post-litigation concerns. Was there an agreement on how the confidential information will be used post-litigation? You know, what if the interests diverge on appeal or in subsequent litigation? You know, one of the interesting questions that has popped up in cases is, will there be ethical issues inhibiting your future engagement on behalf of your client because of the confidential information you received from a co-party that is later adverse? And so you may have an ethical problem with proceeding with an engagement in subsequent litigation with a party to the common interest agreement in the first litigation. Something to think about. And obviously in California, we have to think about the successor trustee issue. You know, as Garen was talking about, the unique issues with fiduciaries. When the litigation is over, often there's a settlement agreement where a fiduciary will resign, or there'll be an agreement that a neutral will come in, and you'll have to give some thought on how to protect the privileged information that was protected by the common interest agreement in that transfer of power. I'll say just a few words about ADR, alternative dispute resolution. You know, mediation, for example, has its own privilege. And so there's a lot of discussion on the interplay between the mediation privilege and the common interest doctrine. You also see this come up in arbitrations. Have the parties explicitly discussed how privilege and common interest issues are going to be handled under the arbitration rules? Are they going to be following specific state rules, or is it more ambiguous? How will the arbitration rules impact issues regarding in-camera review, attorney-client communications versus attorney work product? There are a lot of things that can be spelled out in ADR and are often not. And so it may become an issue up to the arbitrator on how they're going to address some of these issues. We're at the point now where we've done a lot of talking about some of the issues that could come up and the things you need to be thinking about. But we want to sort of finish our time today by talking about some best practices to help think about these issues and protect yourself and your client.
Yeah, one of my, you know, favorite things is to impress upon people is to educate your clients. Make sure they understand which of their communications will be privileged, which of them are likely to not maintain that privilege, and how including other people on those communications and which people they include would likely violate that privilege. You know, a lot of times you have, even in a common interest situation, the co-parties have some sort of relationship that's, you know, independent of the agreement. And so a lot of times you'll have communications that they have, you know, that are separate and apart from just what you're trying to do in the litigation setting, or whatever the the common interest is. And just to inform them that just because we have a common interest agreement with this party doesn't mean that everything you discuss with them will be privileged. Impressing upon them that only the communications related to the specific issues of the common interest agreement could maintain that privilege. Some other things to remind your clients of are, despite having that common interest and that we have maybe a free flow of information, that the other party's counsel is not there to represent them and does not represent them. Reminding them that the common interest doctrine only works to keep existing privileges in place and doesn't apply just, to everything that could be discussed with those other parties. Reminding them that information provided may ultimately at some point be used against them if there are disputes that arise with the other parties that have a common interest. I think that a lot of times you have people just adding co-parties or adding related parties to meetings and phone calls and things like that, just because well, they're brainstorming sessions. Well, those can also come back to haunt your client if they're not careful of who they're including in those calls. The other one that I always like to point out is if your client is a trustee, what happens if they resign or at some point are removed, worst case, or are joined by a co-party? Which of those, what communications now become opened up to disclosure to that new trustee?
Yeah, I sort of jokingly refer to this as sort of the Miranda rights of common interest agreements, where you go in there and sort of impress upon them that this is serious. It is something that we need to understand at the beginning, because once something is disclosed, you can't put it back in the barn. And so ticking off these things as sort of the Miranda rights of common interest agreements is one way of looking at it. I'll also note, we talked earlier about the problem of evidence, but you could also tackle the problem of evidence and the problem of reminding your clients in the same way by labeling things, labeling emails, identifying things as confidential, making sure that, when you're sharing information, that the transmittal email says this is confidential pursuant to common interest agreement. Creating a written record of efforts to maintain confidentiality may help you and your client meet the evidentiary burdens. And so, this is where you have Covell letters, you may have agency powers of attorney created, you may have other things to document the relationships. And so labeling and writing things down become very important.
Yeah, and while labeling is one thing, you can also, separate those calls and correspondence. Separate business calls from legal strategy calls. You know, warn a client maybe when, if you're doing a joint call, when they start veering into some things that may or may not be protected by the common interest agreement, just so there's no inadvertent waiver.
And then this may seem obvious after hearing all of this, but one of our best tips is be prepared, do your homework. If you have multiple jurisdictions, understand the privilege rules and how they vary, understand the common interest rules and how they vary, and also be aware of your jurisdiction's rules regarding the presence of people reasonably necessary for the accomplishment of the purpose for which the lawyer was consulted, language from our evidence code 912, and the use of agents, and how that language and protection might vary if you're in multiple jurisdictions.
Yeah, another thing that seems like it's basic, but it also feels important to repeat is that, ensure your client knows who their attorney is. Unlike a joint representation scenario, the other parties in the common interest agreement and their counsel are not the counsel for your client. And I think that's just important to make sure that there isn't inadvertent disclosure of otherwise privileged information. Whether it's so easy to copy somebody on an email without even thinking twice, or replying all to an email from your attorney without really thinking about who else is on that chain. And so just, clarifying with your client who is actually on the immediate team as opposed to the common interest team.
And I think this point is worth repeating, both because you should be saying this at the beginning of the engagement, and you should be saying it at every instance where it sounds like the other party's attorney is giving legal advice, is you speaking up and saying, well, I agree with them. I'm your lawyer, but this is what I think, so that they don't begin to be reliant upon the advice of someone who isn't their attorney, creating potential issues down the line. And, if you're going to have a common interest agreement, having that oral or written understanding early in the process becomes key. You don't want to have several conversations with an aligned party and then remember, oh, we really should discuss a common interest agreement. You want to be able to say that you hit on it at the beginning.
Yeah, and another thing you can do is try to get the common interest agreement kind of memorialized in, either a case management order or some sort of stipulated protective order that would, allay any questions and concerns about at least the expectation of confidentiality. There are, different ways to do that, but that's one way to do it so that you can make sure that at least there's some sort of record that you had the expectation and that you memorialized it in some way that you can turn around and use that as your proof rather than having to actually disclose communications.
So I'm going to close with two examples, one that should worry you and one that should make you feel positive about this. First is I had a case many years ago that involved two brothers versus their stepmother. Unfortunately, not an uncommon scenario in my practice. But hating their stepmother was really the only thing these two brothers had in common. They never really got along until this litigation. And so they entered into a common interest arrangement where they brainstormed and they were all separately represented. But lo and behold, halfway through the litigation, these brothers who did not get along suddenly did not agree on how the litigation should be settled or proceed and became adverse. And that was a situation where a ton of money was spent arguing over the common interest agreement and attorney-client privilege in discovery battles, which only got cut off when the case eventually settled, but not before the trial started. So I'm going to end with a final example with a happy ending. Let's say you have a trustee and a beneficiary who are aligned against a creditor. By entering into a common interest agreement and jointly preparing a defense, they end up saving the beneficiary money. They create a positive working environment between the trustee and the beneficiary. They're aligned together against the bad guy or bad girl. It creates a positive working environment that could spread to the rest of the administration. The trustee receives added protection by having the beneficiary sort of sign off on joint legal strategy. You won't. It would be hard pressed to say it's a breach of duty when you've signed off on it. And it can lead to judicial efficiency with sort of issue splitting. I'm going to file a motion on this issue. You're going to file a motion on this issue instead of us both working independently, not knowing what we're doing and each filing their own motions. It benefits the court, benefits the party, can save money. Common interest agreements have real application in the trust and estates field.
Yeah, so I mean, I'll end our presentation just by saying, we've seen that, common interest agreements can work really well when things work well, and they can be disastrous when, it's not applied correctly. So, the bottom line when you're doing this is just to be prepared. Like Mike said earlier, do your research and be deliberate. Don't share information with or other parties or enter into common interest agreements just because it's convenient. Make sure that you're doing it in a situation where it will actually assist you in preparing and advising your client or preparing, some sort of legal strategy. And if it involves a fiduciary, multiple jurisdictions, or parties who are likely to possibly change allegiance or don't really have anything else in common, like the brother scenario Mike said, just be mindful of those issues, disclose those to your client, and do try to avoid any, pitfalls like that. And with that, I think we'll close. Thank you all for your time. And if you have any, I don't know that we have time for Q&A, but if you have any questions, you can send them to our emails and try to respond to them after the presentation.
Similarly, if you want a citation to any of the cases we discussed or the
Yeah.
full names, you can reach out to us. Thank you so much for your attention.
All right, this concludes today's program. We would like to thank our speakers today, Michael Brophy and Garen Kirakosian, for an excellent presentation. Our next program will be Gifts with Purpose, Decoding the Types of Testamentary Gifts and Their Consequences. This program will take place on September 10th with Julia Hay and Mark Stern. Thank you all for joining us this afternoon.